we have the habit of just underlining the answer like this. When we write something key area, we used to underline in this perspective. Like that, we used to go for the answer writing. Or we used to as such draw lines like this, like this, like this. We used to give a gap and draw the line. These are the things which we follow as such. But now they are confirming that these type of input, if it is being given to highlight the answer or highlight the key point, it is a strongest message that the candidate is not as such having the maturity to give the answer. The candidate is being assumed that he is not having the confidence in terms of giving the answer. So never ever do the task of answer writing in this perspective. Your answer, if you want to highlight the key point, these type of inputs are not the right method to give the answer. Be very specific in this area. Now we asked them, so then how to go for the underlining the key facts? Generally in state public service commission exam, those things are not permitted. So in UPSC are permitted. How to go for that? For that, what they are saying is, if you want to tell something as important, draw a straight line. If you want to tell that this is a key point which is very important, then even you can draw two lines to tell this is an important area. On the other hand, if you want to convey the message in a very strong perspective, the traditional method of drawing the box is viable. You can do these things to proceed for the answer writing, but never ever go for the element of giving this type of line, dot line or zigzag line, because we ask them what is the consequence. They say these are considered to be the area which in turn will result in negative marking. Negative marking will get as such increased for these area because it shows that the candidate is not psychologically having the confidence to give the answer. This input is really a valid input from examination point of view. He is not a past evaluator. He is a current evaluator in UPSC. So the input given by him, let us take it in a very serious manner so that our answer writing is getting tuned in this perspective. So that's again an important area. Just a piece of information which will help you to score more is getting highlighted in the commencement of our session. Additionally, we have other things also which needs to be discussed here. That is the question aspect of the question number 20, that is called as the area relating to the domain on Central Administrative Tribunal. So what do you mean by this CAT and why we are having this CAT as an issue and what are the things related to the CAT? So first thing is that they speak on the perspective of the Central Administrative Tribunal, which was established for the redressal of grievances and complaints by or against the central government employees. See, these are the core areas which we need to highlight. Nowadays is exercising its power as an independent judicial authority. This is the question. Once again, yes, so now we can resume the content. So CAT, which was established for redressal of grievance and complaint by or against central government employee, nowadays is exercising its power as an independent judicial authority. So before commencement of this area, let me as such brief you relating to this area which is considered to be the content on CAT. So Central Administrative Tribunal came into force just to handle the matter on service related issue. Promotion or any wrong demotion or any amount of delay in payment of salary, unwanted unnecessary transfer. For handling all those things, we are establishing the CAT. That was the basic purpose for which CAT came into picture. After having the element of CAT coming into picture, we got a great amount of reduction in the load of normal judiciary. But now, earlier and all, how the case was that whenever CAT is giving an order, that order remained as a final order. there was no amount of dispute in that. Whenever cat is saying something or cat is doing something, that will be considered to be final. We do not have an option to go for appeal. Appeal was as such not permissible. But nowadays what happened, after 1997 there was a very famous case called as Chandrakumar case. After that case, they said all the orders of the cat are subjected to appeal, not in Supreme Court of India, in the respective High Court as such. Then they can go to Supreme Court for the appeal as such. In this domain, the cat was earlier having a great amount of power, what they thought they can exercise independently. But now we got a louder message that all the orders made by the cat are subjected to the review by the so-called High Court of the respective state and Supreme Court of India. That is the domain. But nowadays what happened, it is exercising its power as an independent judicial authority. Cat is not, technically speaking, a constitutional body. Why? Because it doesn't find a mention in the Constitution of India. Cat nowhere has the element of mentioning as such. Therefore that topic we need to understand very clearly. Number 2, it came only by way of Act of Parliament. Parliament only as such created this body. Part 14A of the Constitution got as such added. Then after 1985 we are having the element of cat coming into picture. Central Administrative Tribunal is something where the Parliament of India have established the Central Administrative Tribunal to deal the matters on the aspects of employment and other grievances relating to central government staff. For state government, we have SAT, which is otherwise called as SAT, State Administrative Tribunal, that will deal the matter of the state government employee. But state government have a choice to keep it or not. So many state governments are not willing to have the SAT. Now the question in this area says that most of the area relating to the aspect of SAT or the CAT is being functioning like an independent judicial authority, which is not technically speaking correct. So now let's start the area. First introduction, what we have to write. We write about the cat and its origin. So part 14A deals with tribunal. So what is tribunal? First thing, please understand, tribunals are considered to be quasi-judicial. They are not completely judicial in their functioning. Why? Because the judicial aspect as such has the power to deal anything and everything. You go to High Court, you go to Supreme Court, any matter you refer, they will deal it. But cat is not like that. They are having a limited domain. Number 2, the cat is having the element of judges, where one will be, technically speaking, a bureaucrat who is well versed in the rules and regulation. Other will be a judicial member who is well versed in the aspect of law. Law plus the executive, the bureaucrat, both of them, when they sit together, it becomes a finite possibility that they pass the order in an appropriate manner. Therefore cat was as such established. So you know the element of cat is considered to be a domain where the matter of cat is subjected to parliamentary control. Article 323A, it is giving the power to the parliament. So please understand, the power is being vested in the hands of parliament, where they can take service matters from court and give it to the tribunal. So whatever service matters are there, promotion, demotion, or increase in salary, decrease in salary, transfer, unnecessary withdrawal of the benefits as such, all those things pertaining to central government employees will be handled by this Central Administrative Tribunal. So here the main task is that technically these are not the main duty of the High Court and Supreme Court. If they start entertaining this issue, in turn it may result in great amount of workload for the apex court and the state highest court called as High Court. These two courts may get burdened. Therefore, to reduce their burden and to bring some amount of conformity in terms of the normal procedure, they came to a grand conclusion that we have to create a body. Primary purpose is to reduce the burden, but not to create an independent court. I will just quote some example to make this concept very clear. For instance, they had an opinion that the Supreme Court of India, which is having the bench at New Delhi, in that you should know that is the provision mentioned in the Constitution of India, Article 130. the seat of Supreme Court shall be in Delhi. That is Article 130. Any other place, the Chief Justice can have the seat of Supreme Court provided he is getting the prior permission from President of India. That is the context as such. Now they are having a plan to bring the benches of Supreme Court. Let's say in Mumbai, in Kolkata, in Chennai, they just want to spread the bench of Supreme Court. While just spreading the bench, they had an apprehension that if we do like this, the originality of Supreme Court will get declined. Therefore, to avoid these area, they just went for the next stand and said, as of now, there is no plan to bring the benches of Supreme Court to other parts of India. Right now, it is in Delhi. Let it be in Delhi itself. We will not change it. That was the opinion as it's recently shared. So, when they do not want to dilute even the bench of Supreme Court, now we have to be very clear in understanding the input that the question of CAT to work independently is nowhere as such permissible. Now, why we are having the CAT? That will be the core area of understanding. One is that CAT is considered to be an expert body. Why we are saying expert body is, I have seen even practically in terms of the functioning of court. Many information what we speak, judicial member cannot understand. For example, let us take the issue relating to dam. When there is a question on increasing the water of a dam, let us take Mullai Periyar Dam in Kerala. In Kerala, Tamil Nadu, when we are having the Mullai Periyar Dam issue, they are telling that we will constitute an expert committee and that members will give a report. Then we will come to finalization. Why? Because judiciary in turn is not an expert body. Therefore, CAT in turn is promoting this content which is called as expert body. They will deal the matter more professionally than what we think. And then additionally speaking, there is a high possibility of quick delivery system. And one more advantage is that you take any matter to CAT, the fees is not more than 50 rupees to 200 rupees. I am talking about the legal fees, not the advocate fees. The judicial fees, what we file in the court is very minimal. Why? They want to ensure that speedy justice system at affordable rate shall be the only agenda for establishing CAT. So that can be given as a merit point to celebrate the aspect of CAT. See, dear students, please understand, when we write an answer, we need to celebrate the institution and then give the way forward. We can't criticize them until otherwise question says critically analyze or criticize this institution or write the flaws of this institution. Until otherwise asked, we cannot go and give those type of inputs. Please be very specific in that area. Now, this particular body is a combination of judiciary and administrative body. Why administrative body? One member who comes and sits there will be a former judge. Number two, administrative body, because it will be having a person who is coming from bureaucratic background. So bureaucratic background, one man, so administrative body, a judge, retired judge of Madras High Court, therefore, or any High Court as such, a judicial member. These two members put together will decide on the decision making. Therefore, we have an opinion that the grievance of the employee from the central government is getting addressed at the earliest. Most importantly, the big problem relating to the judicial system is that what we feel is Civil Procedure Code 1908, Evidence Act 1872. These are the biggest problem what we witness in case of normal court. Many times we have seen the wrongdoer, an accused involved in the murder is getting released. Why? They say as per Evidence Act it is not possible to prove the evidence. When evidence cannot be proved, then the man should be assumed that an innocent person and we have to release him. That is the basic law of this land. But when it comes to CAT, these are not applicable. 100% speaking, these do not have any amount of application. When these are getting as such a great amount of relaxation, we can tell with conviction that CAT is highly speaking a best body to deal with all these grievances. I can go and tell the problem faced by me, but I can't prove everything. Yes or no? See, generally when there is a question relating to an offense, we can't prove each and everything. There is a big possibility that we may not prove it, but we are a person who got a great amount of loss because of that activity. Some activity would have caused loss to you. Some activity would have caused some amount of inconvenience to you. But when you tell those information in a chronological order, the opposite person will clearly understand that you have undergone a problem that is getting established in CAT. You tell me, other than this body, there is no other place where they go by the element of avoiding these things. Anywhere, everywhere, they will ask about evidence, and all the content of procedural formalities as such. Those things are not applicable. That's the reason I say CAT is really a powerful body. Again, to add fuel to our answer, we can say that this particular CAT has been entrusted with the power of a civil court. They can summon the individual, they can question the individual, they can go for the issue relating to taking the documents to prove the data, they can ask any person to come and give as a witness. All these things they can do. So, like how a civil court will function, this CAT is functioning as such. When that much of power is getting entrusted in this body, that conveys the message that CAT is really speaking one of the powerful institution which is able to have an upper hand relating to this area. So that comfort a CAT will give. And then CAT will not only deal with after the element of the so-called employment, but even with the issues of appointment. Appointment issues are also being dealt here. When there is no proper appointment, when there is an opinion that the appointment is not based on the principles of merit, when there is an opinion that the central government is doing something very wrong, then we can proceed for the CAT. But if you remember, recently speaking, in case of UPSC, people went to CAT. They said CSET examination was very tough. It was above the level of class 10, what notification says, IIT, IIM, to that level they phrased the question. We are not able to solve it. That was the area what they discussed. But now what happened, this particular CAT gave a notice, but they said we can only ask them what is happening, but we can't give instruction to them and tell that you stop publishing the result. Because if I remember, once CAT gave a notice, very next day UPSC gave the final result that those who have cleared, those are not cleared. So generally speaking, even before the element of getting appointment related matters are highly subjected to CAT. And then CAT judgments are subjected to appeal. So please remember the case law which is called as 1997. The case law is called as Chandrakumar case law. Chandrakumar case, a very important case relating to the aspect of this particular issue on appeal. Earlier and all, appeal was not permissible, but now it is permissible. After 1997, they said CAT judgments cannot be seen as a final thing, because to go for judicial review or to file an appeal is a part of the basic right what everyone is having. Therefore, that has been now thrown open. But here, the issue is that CAT cannot be treated like a constitutional body. It doesn't have any amount of status emerging from constitution. It is no more a constitutional body. Therefore, that is seen as one of the biggest limitation of the CAT, as it got established by way of Act of Parliament. On the other hand, the CAT is being given a good merit because it helps to reduce the load of judicial. Normally, what a judiciary will do, now CAT is doing. So many work relating to the aspect of employment, appointment, all those things are being taken care by the CAT, particularly on the government employee from central government. When they are able to deal these things, it is the strongest message that the CAT is able to solve the matter without any amount of much difficulty. Now, what is the conclusion? What we will write? CAT is not a full judicial body. Therefore, it needs to work in the aspect of depending on some other body which is a constitutional setup. And here, like how an independent status is available to a constitutional body, CAT is not having. When CAT doesn't have those things, it is again a limitation. Therefore, this particular body cannot be entirely left as an independent body. All its activity needs to be checked. Indian system is purely based on the principle of checks and balances. There is no strict separation of power. When we do not permit this, the institution of CAT has to work in collusion with the higher judiciary of the state as well as the Supreme Court of India, wherein which that functioning alone can be considered to be an ideal constitutional institution where it can work in a manner which is applicable as per the law of the land. This is what the answer. Therefore, if you deal this question, the CAT established for the redressal of grievances and complained by or against the central government. Nowadays, it is exercising the independent power. But in the conclusion, what we are saying, this particular CAT, though it is not a full judicial body, though it is not having a constitutional backup, the expectations of the CAT to work independently cannot be accepted. It cannot be celebrated. So what it should be? It should be subjected to the perspective where the working on independent line cannot be permitted completely. It has to work in hand with the other judicial organ. A complete independence to a body in India cannot be entertained. So your answer should be like this, then only it will be subjected to reward. Otherwise, you will not be getting the mark. Therefore, be very cautious in this area, right? Okay. So now, information as such, the batch relating to the UPSC. So we are having the commencement of batch on July 13. So here we are given the phone numbers also. A complete 1 year batch is available. So do contact the academy. They will do the needful. Phone number is available at the end. Now to go by the next question. Right. So in this area, Parliament's power to amend the constitution is a limited power. It cannot be enlarged into absolute power. So first thing, two terms are there for our better convenience as such. One is limited power, number two absolute power. I'll explain this thing initially. Limited power is something wherein which you cannot do things beyond what the provision of the law says. Absolute power is something where there is no limitation. You can do anything and everything whatever is required. That is called as absolute power. In light of this statement, explain whether Parliament under Article 368 of the Constitution can destroy the basic structure of the Constitution by expanding its amending power. Such a beautiful question. They are asking the power of the Parliament. They are telling that it's a limited power and it cannot be as such expanded to absolute power. In this particular area, they are telling that by using Article 368, which speaks about the amendment procedure, whether the Parliament can enlarge this provision or not. That is the question being asked here. So how to as such go by this answer? So what are the information we are supposed to give and how to have the element of this amendment? 15 mark question, no. So we have to write bit briefly. We can't give a very simple answer for this 15 mark question. 250 words you need to write. Therefore, you have to make the presentation in a comprehensive manner. First thing, what do you mean by amendment of Constitution? That we have to say. So how you will start? Constitution of India is a living document. It is not subjected to extreme rigidity. It is not subjected to extreme flexibility. It is a synthesis of both rigidity and flexibility. First point we have to write. The provision of amendment is getting mentioned in Part 20, Article 368, that speaks about the procedure how to amend the Constitution. Amendment of Constitution includes number 1, adding a provision, number 2, modifying a provision, number 3, deleting a provision. We can delete a provision completely or removal of a provision. These three things will get as such possible by way of amendment. A constitutional amendment is definitely possible in this area. In this perspective, one louder message what we want to convey is, whenever there is a topic relating to the Constitution that needs to be handled from a larger perspective. So Constitution, if it is being made as a rigid document, now it will become a document which is called as outdated Constitution. But now, just because this document is subjected to acceptability, we come to a grand conclusion that this Constitution is again subjected to the belief that the Constitution is not a dead document. You can modify it whenever and wherever required. And for this, you have a procedure, right? So, constitutional amendment, you can do it anywhere. that is either in the Rajya Sabha or in the Lok Sabha. So one unsaid rule is that in the state legislature amendment is not possible. You bring this legislation, you make the amendment. Then what happens? The introduction of this constitutional amendment bill will happen either in the Lok Sabha, Rajya Sabha. Then they will have the discussion. They need the approval of both the houses, and once the bill goes to the President of India, constitutional amendment bill, he cannot refuse it, he must give the signature. This is the content relating to constitutional amendment. Now this possibility is there. Now a big question is that whether Parliament can make this power and destroy the constitution. See, destroyal of constitution means what? Writing and rewriting the constitution however we want. That is called as destroying something. You do things for your favor. You do not do things which is actually required. So when you are doing things which are not actually required and you are doing just because you are staying in power, you will dilute all the provision. There is something called as a basic structure that cannot be diluted. Therefore, the question is whether Parliament can dilute these things or not. That is the simplest question they are asking in this area. And for this, always speaking, tussle goes between judiciary and Parliament. Who is powerful? At last, judiciary pronounced a wonderful judgment in Kesavananda Bharati case. In that, they said very openly that yes, all power is there in the hands of the Parliament. They can change, they can do anything and everything. But one small condition is when you change, you have to ensure that you are not changing the basic structure. What do you mean by basic structure doctrine? That was not explained by this so-called judiciary. They made this provision crystal clear. They said, come on, you change anything and everything. After listening to this news, parliamentarians became very happy. Then only the twist was that they said without altering the basic structure, you can change anything. So now when we look upon the question, limited power to absolute power, no more it is possible. April 24, 1973, Kesavananda Bharati case. Mutt, so a person from Kerala, he filed the case relating to the aspect of the basic fundamental right, and in that Supreme Court of India gave a wonderful judgment that no, it is not possible. So now in this, let's move on to the domain. How we will start the answer? We will give the article. Article 368 of the Constitution in part 20 deals with the procedure for the amendment of Constitution. An amendment of Constitution is all about changing the provisions of Constitution by adding, by deleting or by modifying the existing provisions of Constitution. An amendment is definitely a possibility where the provisions are getting changed to fulfill the demand of the day. This is the basic thing what we have to write. Then we will write about threat of parliamentary provision led to SC interference. That is very much required. Supreme Court of India didn't interfere just like that. They said, come on, you can change anything and everything. Then after that, there was a big amount of tussle going on in the parliament where parliament was doing things on their own whims and fancy. They were not subjected to anyone's opinion. They had a biggest hope that they can do anything they want. Now, Supreme Court is interfering. They are coming and telling that, wait, we cannot as such remain silent. Because the highest person to interpret the Constitution in India is Supreme Court of India. So they came and said, wait, we will give you some input. Based on that, you can proceed. Then only we came to know about the judicially introduced doctrine, otherwise called as basic structure doctrine. This got as such introduced. After having this provision, we came to a large conclusion that yes, the element of the so-called opinion of Supreme Court of India has saved the Constitution. 50th year right now after Kesavananda Bharati case, 2023 I am saying. 50 years got completed. So April month long back got over. Therefore 50 years got completed. 50 years we are able to maintain the spirit of Constitution only because of this basic structure doctrine. So you need to celebrate this doctrine. Otherwise speaking, this will not have any bigger value. And in that, the element of intelligence of judiciary is that they never revealed what do you mean by basic structure doctrine. After having these things, the judiciary was able to restore the confidence of the so-called constitution into the minds of common man. In Kesavananda Bharati case, the Supreme Court of India declared that we have to go by basic structure. In continuation of that, in Chandrakumar case versus Union of India 1997, the judgment held that every provision of constitution, you see this line, very important, the same case I told you for tribunals also, every provision of the constitution was open to amendment provided the basic foundation or structure of constitution was not damaged or destroyed. This is the input relating to the area. So they have made the provision crystal clear. They are telling that the judgment is giving the opinion that whenever there is a question to amend, Parliament is fully empowered. We will not come and interfere. But one condition is that do not alter the basic structure. That got reconfirmed. That is not the original message in this case. Please understand. Original message of basic structure evolved in Kesavananda Bharati case. For that I told you the date also. It is based on April 24, 1973. That is different. Again in 1977, they are reconfirming the message. You have a right to change it, no doubt in that, you can go for that, but one precondition is that never ever go for the element of as such making any judgment or any law or any particular orders in which you are going to destroy the basic provisions of constitution. Without destroying the basic provisions of constitution, if you change anything, we are well happy in that we will not interfere. So now what happened? Parliament became happy as they got the right to change things however and whenever they want. This is how they started the element of this particular basic structure doctrine, and from here only the proceedings happen. And what are some features of basic structure? We have to write supremacy of the constitution, or we can say whatever provisions like federalism, secularism, whatever Supreme Court has said in each and every judgment which is called as basic structure doctrine, do come and have those words here: independent judiciary, rule of law, parliamentary form of government, separation of powers. These are some of the input given by Supreme Court of India. Give all those things, right? 5 or 6. Your answer will look like from these input, it is a message crystal clear that Supreme Court of India didn't tell a list which is a final list. They never revealed that, come on, these are the things. Within these things, you are bound to have the power to change anything and everything. They never said like that. They are always subjected to the element of keeping the basic structure doctrine open. It's open. It's highly subjected to openness. It do not have any amount of activity in which we are subjected to find a list of document called as basic structure. When list is kept to open, any law made by the parliament is subjected to the test of basic structure doctrine. Otherwise speaking, parliament will ruin the constitution of India. For that only, judiciary has saved the parliament by doing these activities to a large extent. And now the confirmed message is that constitution is a living document, something which is alive. See, alive is that we are able to deal the matter in a perspective where we do not have any amount of apprehension. We never feel that the constitution can be subjected to a dead document, and there was no need even to bring big changes also. We feel comfortable. At last, the rulings of judiciary modified the provisions of constitution based on the time and space. Arrangement of event is called as time. Arrangement of objects is called as space. So time and space, they have reconfirmed the message that the constitutional document is now subjected to modification based on the rulings of judiciary. So this we can write and we can wind up the answer. So answer in this area has become very clear. You see, whether they can destroy it or not, no, they cannot. For that we proved via basic structure doctrine. Number 2, we also spoke about Chandrakumar case law 1997. Then we said it is a living document. Then we said there is a basic structure doctrine. Without altering that only, the parliamentarians are being empowered to change the provision. When we give all these inputs, the final message is now very clear. What is that? You cannot change things what do you want. That means limited power is there for the parliament. They do not have a unlimited power. When unlimited power is not there, when they are having a limited power, it means it is subjected to a large amount of power which is called as limited power. It is not absolute power. They cannot destroy the constitution. So our climax in this area will be that judicial ruling has only modified the constitution. Parliamentarian cannot destroy the constitution to a large extent. If you think they can destroy, you are wrong, because the power of parliament is always limited. That reconfirms the message that structure will not get altered. That's the area in this perspective. Now moving on to the next question. The Attorney General is the chief legal advisor and lawyer of the Government of India. Discuss. That is the question they are demanding in this topic. Attorney General, that is the first law officer of this country, is called as Attorney General. He is the chief legal advisor and lawyer of Government of India. Discuss. That input is being demanded as a 15-mark question. So we need to be cautious to give the answer in this area. We all know in case of the executive, we used to call the people like President, Prime Minister, Council of Ministers, all those members. At last, when we speak on the Attorney General also, who is a part of the executive. So we always give the highness to the office called as Attorney General, and all the legal issues are being dealt based on the input and advice given by Attorney General. So any query as such comes, first person to be approached by Government of India will be Attorney General. And he will be representing the government in case of the judiciary whenever government is in soup. When government is having a problem, when people come and file a case in the court against the government, whether in the state high court or central Supreme Court of India, anywhere they can come and represent the so-called government, and they can fight for the government stand as such. This input conveys the message that law officer or the first law officer, or in case of chief legal officer, everything rightly applies to Attorney General. So please understand the provision. How do they go by Attorney General? Constitutionally speaking, they should be eligible to become the judge of a Supreme Court so that they can become AG. I am very clear. I never said they should be a judge of Supreme Court. What I am saying, they should be eligible to become a judge of a Supreme Court. What are the criteria? 10 years of practice as a High Court advocate, or they should be having 10 years of some judicial service like lower court judge, all those things, or they should be a judge of a High Court to become the judge of a Supreme Court for 5 years, or they should be a eminent jurist in the opinion of President of India. No lawyer, nothing. Even without law degree as a background, if you are an eminent jurist, you can be appointed as a judge of Supreme Court of India. So, a eminent jurist also is eligible condition. In that, even that person can be appointed as Attorney General. And this Attorney General will be dealing the matters to a large extent from Government of India's side. So a question comes, sir, whether he is eligible for practice or not. Yes, Attorney General is eligible for private practice, and only condition is that he cannot go and defend any criminal case. Why? Because criminal case will be filed by the government. He is a person who speaks for the government. So in criminal case, when he is going and filing a petition from the accused point of view, it will go wrong. That's the logic behind he not involving in criminal cases. Civil cases, he can go and proceed. There's no amount of limitation on that. These area we have to remember. So first thing, we spoke on this topic. Now let's move on. Who is the person of AG? How it is going on and all. Role and duties of Attorney General. That should be the intro. So what he will write? He will defend the Government of India. He can have the audience into the Parliament of India, and he is the only person to go and sit in the Parliament of India without being a member. But he doesn't have a right to vote. Voting rights are being denied. He will not have that right as such. Without that right, he can go sit into the house and listen to all the issues, whatever is happened. So a question comes, why is he going into that area? Why? What is the reason for him to go and sit in the house? Simply speaking, only when he goes and sits into the element of the so-called parliament, he will know the stand of the government to speak in the house of parliament. That is one of the prime reason. And number two, Attorney General happens to be the chief legal officer. So any legal issues here and there can be resolved with the help of this person called as AG. And then what are the duties? Even when there is a need to defend the government in state high court, he will go and defend. And he is also considered to be a person where the appointments is being made by President of India. Remuneration, all those things will be paid by the central government as such. And this post doesn't have any security of tenure. Whenever president feels they can remove him, there is no guarantee that once appointed he will stay in the power for next 5 years. All those things are only a myth. In reality, that will not work out. Now we will write about Article 76 that deals with Attorney General. What about Advocate General? That will be dealt by Article 165. So articles here and there, do remember to write the answer. See, whenever I write an article and start the intro, I will get a reward. Yes, that is a confirmed message from evaluator. That too for GS2 article, GS3 facts. These are very much essential, and that's what the examiner expects from the aspirants to a large extent. Right. So after writing these two things, we'll go for the body. How AG is appointed. AG is appointed under the warrant and seal of the President of India, and AG will be a person qualified to become the judge of a Supreme Court, and AG shall hold the office till the pleasure of the President. Normally, when the government stays in power, the AG will be there. Once the government changes, the AG will resign. New Advocate General will get appointed. Advocate General is having the right to defend the government in all the courts across the length and breadth of India. And this Advocate General, once appointed, shall not be restricted from private practice. Even own cases he can take and handle. Only condition is he cannot go and file a case which is criminal in nature. All those things we have made very clear. After this, we have to understand the element of his mandate. Mandate is quite simple. He will represent the government. He will speak on behalf of the government. He will be assisted by Additional Advocate General and Solicitor General. All these posts, what I am saying, is not a constitutional post. They are being appointed to assist the Advocate General. And this man in turn will be involved in these activities, which is again considered to be a big amount of mandate on behalf of Advocate General. And then why we need AG? See, Advocate General is required for two things. One, he is a man who will defend the government. Number two, he is a man who will clarify the legal disputes of the government. The law is again considered to be a evolving subject. What applies yesterday won't apply today. When so much of ambiguity law is having, we need to reconfirm the element of law in right perspective. When government is taking a stand, opposition party may defend it. They will say it is legally not permissible. At that time, he will be a man to explain the provision. And number two, this particular man will help the codification of the policies of the government as per the provisions of law. And these are the biggest advantage why we are having the post of Advocate General. So AG are considered to be a defense lawyer for the government, a supporting person for the government, and that's where his role is getting enhanced. When there is no person to speak, when there is no mouthpiece for the government in judiciary, then who will come and speak on behalf of the government? When nobody is willing to come and speak in terms of the government stand, then obviously it will become a big flop as such for the government. They will lose many cases. Therefore, to defend the government in a right perspective, we are subjected to the post which is called as Advocate General. Now, how we will conclude the answer? Advocate General is considered to be the first law officer of India, and he is rightly being given the status as he is appointed by President of India. He defends the government and he is a person entitled to sit in the parliament. And there are many examples like the Advocate General representing government in case of Sabarimala case. And always please understand, AG representation is nothing but a government stand or government's particular policy will be represented in judiciary by this person who is called as the Advocate General. This is all about the intro relating to the question and the conclusion part of this question, which is considered to be the domain on Advocate General. So now we are very clear. We have made the input crystal clear that how this AG is there, how he is functioning, and what are the areas in terms of his function. So these input do remember. Now 23. So before this, again a small recap. So commencement of batch will be on July 13 for the entire like 1 year, and the details are available in this particular shot. So below we have the Sriram's phone number. Do call the academy. They in turn will assist you in terms of admission. So all 8585858585, right? So 85 for 5 times when you dial, you'll get the academy's contact number, right? Okay. Now going on to the next one. Individual parliamentarian role as the national lawmaker is on a decline. 100% it is there. There is no doubt in that. Which in turn has adversely impacted the quality of debate and their outcome. See, this problem, that is the individual parliamentarian role as the national lawmaker, is on a decline, and this has adversely impacted the quality of debate and their outcome. This is what is the question. Question is very clear in this area because these are considered to be a very big problem. Now, how to proceed in this topic, how to have the input in this area, that we have to discuss. And for that, we need to be very clear in understanding the context of how this particular issue gets kickstarts. So, individual parliamentarian role. For example, the question is, what the demand of the question is, I am an MP. After becoming an MP, people only have given the vote to me. I am a Lok Sabha MP. I am going to Lok Sabha. I will have something as an agenda. What the constituency people demand, what is the general problem they are having, what are the apprehensions they have towards the government. I will have all this issue. And I will have an opinion that I have to go and speak all those things. But my party will have a stand. What my party thinks as important may not be important to me. And what is least important to the party will be of highest importance for me. Now a question comes, what I am supposed to do? Whether I have to go and do the work or I have to remain silent, that is the question. So here we are subjected to a large amount of conflict of interest. And this conflict of interest in turn will create a great amount of state of sorrowness. The MP will feel that being an MP, I cannot do anything. So he feels less empowered. At last, the debate and the outcome in the parliament does not stand the element of winning status just because of this condition. Therefore, we need to be ultra cautious. We need to understand the provision. Otherwise speaking, in this area, it's very tough to proceed forward and have the provision in a right perspective. Therefore, it needs to be a greatest provision that parliamentarian, when they go to the parliament, should have some liberty in their functioning. If they are being treated like a caged parrot, then obviously speaking, there is no amount of role for the MP. MP should be a man to deal the problem of the public, but the voters are now being subjected to a big amount of disappointment just because the party controls everything to a large extent. That is the demand of the question. Now we are very clear what the question is demanding, and we also spoke about the issues. Let's start the answer. First thing is that the member of parliament work based on the party and not on the individual side. That is the first issue we need to address. Most of the members of parliament, they work only based on the party. Party will have an ideology. I'll just tell you, there are many parties, regional parties. They will speak only from a regional perspective. For example, let me tell a condition. For instance, MPs from Tamil Nadu, when they go to Delhi, whenever there is a question relating to Indo-Sri Lanka business accord or any India-Sri Lanka business issue, Tamil Nadu MPs will say stop having a deal with Sri Lanka because they are the one responsible to kill the Tamil people in the Elam land when LTT leader Prabhakaran was alive. And even till today atrocity is going on, therefore stop supporting the government of Sri Lanka. But an individual MP will think in the long term the question relating to Indo-Sri Lanka is required, otherwise it will create more amount of tension. This is his individual opinion. But party says stop having a deal with the question of Sri Lanka. In the parliament, when a debate is going on, shall we support the Sri Lanka or not? I will think I have to support, but my party will say do not support Sri Lanka, and for that not supporting, when they ask me to raise the hand, I have to raise my hand. You see, this is the current working condition what we have inside the Parliament of India. This may look highly atrocious because individual liberty does not work in case of party. Yes or no? What I want to convey, what I want to plan, I am not able to do it. When I am not able to do that, that itself shows parliamentary democracy fails. Parliamentary democracy failed, and this is again very bad. That is the reason this affects the role of parliament to a very large extent. Parliament is an institution which should deal with the principle of meritocracy. But what is happening here? More than working on the principle of meritocracy, they are working on the principle of party lines. And when party line is there, individual MP hardly has any say in this area. When individual MP is getting dejected, obviously healthy debate and discussion will not take place in the House of Parliament. With that, proceed with the answer. Individual role is declining. Yes or no? Why role is declining? Because all the voters in case of India are getting associated with the party leader. So the role of individual hardly matters. There are many instances where party leader will be in hospital. He will be somewhere. They will show the photograph of the party leader. People will give the vote. That means voting happened not because of individual but because of the party leader. So here we are having a big amount of issue which is creating apprehension into the minds of the parliamentary. Number 2, anti-defection. Come on, a biggest threat. We brought this anti-defection only to ensure that when there is a person who is involved in anti-defection, that means jumping from one party to another. And here also there is a 3 difference there. I hope you know that. For a man who is coming from, let's say, a man who is coming from a party, he cannot go for other party ever. A MP who is subjected to nomination, he has to decide whether to join some other political party or not within a time span of 6 months. On the other hand, a person who is considered to be an independent candidate, that means without any party who joined, can never as such join any political party. But one exception is if you are joining or if you are coming from a political party when 2/3 of the entire strength they are going and joining with the existing party or creating a new political party, this will not come under anti-defection. One more thing, when the party leader has condoned or he has said, come on, I forgive you, come on, you made a mistake, I understand that, but I forgive you. When they declare that, anti-defection will not be applicable. This is the entire provision relating to anti-defection. So why this was brought? To ensure that there is a discipline among the MPs after winning the election. They can't behave in the way what they like. For that only we brought this particular anti-defection. But now what is happening? When MP says anything, when MP is going against the whip, who is a whip? Like a class leader. Inside the class we have a leader, no. Likewise, when teacher is not there, leader will take care. Likewise, when party leader is not there, whip will be a person to take care of the proceedings of entire parliamentary thing for their party MPs, not for the entire parliament. In that area, the person who is a whip, when he says something, we have to obey it dutifully. Sir, if I don't obey, what will happen? They will remove me from the political party or they will charge anti-defection on me. Then there will be a by-election, which is again a very risky thing from the MP's point of view. Next one, unwanted hype by social media. Why individual role is declining is they create unwanted hype which is not all required. Particularly the advent of the digital media or social media has corrupted the system to a large extent. Technology comes with both boon and bane. More than the boon, the bane is increasing because we are not able to do any big activity. Even a small issue. You see this line I have mentioned, party is getting divided for fringe reason. A smallest issue. He didn't wish the party leader when the leader was coming. He would have seen somewhere or have missed it, not intentionally but unintentionally. For these things also party is getting divided. Therefore, there is a big amount of fear into the minds of individual MP where they are not able to do any big reform as such. How it is affecting the debate? What is happening? First thing is that many MPs either abstain or they take a leave. Abstaining is very easy for them. They will just they will not give the vote. They will just tightly hold their hands despite they have an opinion to raise their hand. Point number one. Point number two, when there is too much of commotion, when their conscience doesn't permit them, then they will take a leave. They will not come to the parliament itself. You see how bad it is. We think, hang on, he became an MP, he can do anything, everything, whatever he wants. But in reality, he cannot do that. That is the element of issue relating to this topic. And MP from party can't be a true people representative. Finest topic in this answer is this one. MP from a party can't be a true people representative. He can never be as such. Because the question here is very simple. When he becomes a true people's representative, he needs to be slightly cautious, but that will never happen. He will always have the opinion that he is a man subjected to a big question on the aspect of parties association, not people's association. People's demand will remain as a demand only for next 5 years. Then again, the question of healthy debate will never happen. He will have the question in mind. He would try to ask it also, but he will not ask. Because when he asks any question, that will again spoil this area to a largest extent. Thumping majority affects the decision. When some party wins with thumping majority, no question, they are having sufficient number of MPs. If you need 274, they are having 325. In that area, one particular MP or individual MP, his voice will be highly unheard. Nobody will even think on what he is saying. And then most importantly, MPs cannot go against the whip even if they feel it is bad. I told you Tamil Nadu issue on Sri Lanka. When individual MP feels no, the whip is giving a wrong direction, I should not support him. Even when he thinks in that perspective, he cannot move and accept it. When that is the criteria mentioned here, we need to be ultra cautious to understand that this issue of as such going by the decision of individual MP will hardly have a say, and this is again a big negative thing from the perspective of individual role. Way forward, what we can do? Anti-defection should be used only on major issue. For all fringe small issues and all, don't go for anti-defection. What are you doing in that? When you go for anti-defection, everybody will be having a fear. Anything, everything I say, when you test it with anti-defection, it conveys a message that you are threatening me in some perspective. By doing that, the so-called MPs will start losing the the interest or desire to be as such getting associated for people's problem. And then parliamentary debate shall not make whip to be present mandatorily. Sometimes it should be in the absence of whip also. So sometimes they have to speak what they want. Every time whip should not come and interfere and keep on having an eye on the individual MP, as this will ruin the system completely. Therefore, this cannot be as such accepted. Voters education mandatory. If I give to this person, he will deal. or if I give to this person, he will be a party person only. That is required. Empowerment of the voter, education of the voter is mandatory condition. We have to bring this. Only when we bring these area, then it will give a confidence among the so-called MPs to do something. When voters are not educated, then they will do things in a way what they like, because they will give vote on the party line. At last it is not possible. Therefore, only a vibrant individual MP shall do all effective functioning, failing which it is not possible for him to function in a transparent, open and hearty manner. His heart will say something, mind will say something, but he can't do both of them. The instruction given by whip will be the final stand taken by an MP. And for achieving these things, only a vibrant individual MP shall do all effective functioning, failing which he cannot do anything. This is the input on this area. Please be very specific. If you have understanding in this topic, it will again give a good amount of content how to proceed for answer writing in these area. Now, question number 24. Under what circumstances can the financial emergency be proclaimed by President of India? What consequences follow when such a declaration remains in force? That is the question. A very easy question, as such, by looking at this question, an aspirant who has read Lakshmikant book, as such, will feel very happy. Hey, come on, my question has appeared, I will do justice. That much of easiness this question is having. I will decode this question to a large extent to make the concept look very easy and the element of understanding the answer also. In this area, the logic for this question goes with the assumption that the so-called financial emergency, when it will be proclaimed, and what are the consequences when will follow when you make the financial emergency. First thing is that this provision which is there in the constitution, we have never applied this even once in the history. You all know India was subjected to financial emergency in the year 1991. There is no doubt in that. We had very few $1 million at our disposal. Today we are having billion. On those days, few $1 million were there, which we can use for purchasing oil in the international market. After that, what happened? The so-called financial status was very poor. Indian economy was subjected to great amount of difficulty. Still, we didn't go for financial emergency. What is the logic? I will just tell you. For example, you tell to your neighbor, sir, my income is 100 rupees, my expenditure is 500 rupees, I want 400 rupees loan. Because he knows you, he will fund you. But what he will think on you, that you are a man who is not fit to administer the finance in a proper way. He will have a bad opinion on you, that is damn sure. In this perspective, when we go for the answer, they convey a louder message that the question relating to financial emergency, if imposed by the government, will throw a message to the entire world that India is a country which does not know how to administer the finance in a proper manner. That is the first topic which will bring a big amount of problem. And this issue in turn will create so much of commotion, because they will convey the message so strongly that sometimes speaking, investors will not come to India to fund or to start a project. FDI, FII will not come to India. Therefore, to control these things, we will never go for declaring financial emergency. But Ambedkar, the maker, the drafting committee chairman, has made the provision as one topic, because he thinks when such conditions arises, parliamentarian should not be blinking and winking, what to do. For that only the provision is there. It does not convey a message that we must definitely incorporate these provisions in our area. That was not the area of interest from Ambedkar's point of view. So what do you mean by financial emergency? When the finance of India, credit of India is put to threat. When the finance of India or credit of India is put to threat, then by default the parliament is empowered to proclaim financial emergency. Article 360. So when financial emergency is being declared, it conveys a message that we need to follow the canons of financial propriety. We have to go by the issues of controlling all expenditure. That is the reason, for example, I'll tell you, we will just go by the time of the financial year, April 1 to March 31st. Suppose by the end of June 30, they are bringing financial emergency. By October 1, government became very stable, but still whatever conditions were there in financial emergency will continue till March 31. So this conveys a message that the question relating to the aspect of financial emergency will be subjected to a large question of interpretation. That interpretation says as long as we are using the financial emergency, it should be subjected to a condition that no more we can save ourselves. The entire nation is being put to threat. The finance of India is being put to threat. Then only we can go by using the financial emergency. Otherwise speaking, we can never go for the financial emergency. That becomes a clear area of understanding. So we are pretty well sure in this topic. So it shows that somewhere expenditure is going beyond the income. We need to be cautious to handle these things. Now bodies. So in that what we will write? Ground for declaration. So when there is a threat for the finance, or when the credit of India goes beyond a point of time, when expenditure is increasing more than the income, then we will go for declaring the so-called financial emergency. Otherwise speaking, there is no need to have the financial emergency. Only on these area we will declare. The threat may be a possibility, or it would have happened also. The emergence of a threat or likely chances of a threat coming from the finance point of view is a sufficient ground for declaring the financial emergency. So now we are very clear in this topic. We will make the idea simple. Now financial emergency is being subjected to judicial review after the 44th Constitutional Amendment Act of 1978. When you declare financial emergency, it is not like they will remain silent. If the conditions or the ground for declaring financial emergency according to Supreme Court is wrong, they will revoke it immediately. They will tell no, the ground upon which you declared the financial emergency is not acceptable, is not tenable. So they will again cancel the financial emergency. So time and again, one message is loud and clear. They are conveying that whenever the question of financial emergency comes into picture, we need to handle it perfectly. Failing which, this topic will be subjected to judicial intervention. What they will follow? Canons of financial propriety. So that means what? Everything will be counted. All expenditure will be taken care, and they will ensure that money is not getting wasted anywhere. That is the first principle they have to follow. And now when financial emergency is getting declared, they can reduce the salary of all. Sir, what do you mean by all? All means, technically speaking, every government official. What about High Court and Supreme Court judges? Yes, including them. What about President of India? Even he also is a part of this salary reduction. So here the message says that salary can be reduced of each and every person to any extent. Why? Government is having less money. Expenditure is high. They have to manage all. How they can do it? The only possibility is to reduce the salary of all the members so that we can attain some stability and then revoke the financial emergency and bring back the normalcy. Money bill shall be reserved for the president concerned. They can tell all the state legislatures, you reserve your money bill for the president. So after passage of the bill, let president give the assent. Then we will sanction the fund. Otherwise, you are not supposed to have the element of expenditure from the state exchequer. So center will take care of the state. They will convey the message that these issues will be dealt only based on the current ground situation. You can't decide everything. We will tell you. The state will be completely controlled by the center. Center will decide everything, and center, whatever they say, will be the final statement in this area. They are having a mandate to ensure that this financial emergency is getting controlled. See, just assume India, if it is not having the forex reserve, if India doesn't have the financial issues, then it conveys a message that in this topic, the so-called funding what the center or so-called funding what the union government is not having for importing oil may result in hartal, may result in law and order problem. Therefore, to bring stability, it becomes a constitutional mandate for the entire central government to take care of the state government. Until otherwise they do this, it is not possible to proceed. Once approved, it goes without disruption. Again, 6 months once approval, like our national emergency, Article 352, it is not required. Once approved, it can go for n number of years, 5 years, 6 years, 10 years, it can go for any number of years. That shows financial emergency is so serious. And then revocation of this financial emergency, that means cancelling that and bringing back of normalcy, does not require the parliamentary approval. Parliamentary per se will not have any amount of approval in this perspective. These are the area which we need to remember from examination point. If you understand these things, it becomes quite easy to proceed and have the answer. Otherwise speaking, if you write other area, marks will not be rewarded. Next one, conclusion. During financial emergency, center take care all control over the state. Entire state will be taken care in terms of financial area. Money bills are getting reserved. Therefore, state will be functioning, but all instructions will be coming only from the center. And we can conclude this by saying, though we have financial emergency, one of the finest tool available whenever there is a constraint, as a matter of fact, we have never ever gone for using this financial emergency in the history of Indian democracy. From 1950 till 2023, current date, there is not even once a past message where we have utilized this so-called financial emergency, right? So let this be the answer. Now, question number 25. Whether the Supreme Court can settle the political tussle between the Lieutenant Governor and elected government of Delhi, exam. So the question is, the Supreme Court is having the power to settle the matter between the governor and the elected government as such. That is the question. Here the message is very simple. In July 2018, a judgment came from Supreme Court of India whether it can solve the problem or not between the Delhi government and the Lieutenant Governor. Always speaking, governor and the government will be having a problem. Governor is the agent of the center. So governor being the agent of the center, we always have some apprehension that this man will be working only for the welfare of the appointing authority. He will not have any issues relating to the government. In this, there is a problem. Who is having more power? Whether the Lieutenant Governor or the MLAs who are getting elected based on the people vote. Whether people's representative or an agent, who is powerful here? Both of them, it looks like powerful, but at last, whether people's representative or the central government agent, who is considered to be a powerful man, is the question what comes into the minds of people. And for that, we cannot tell in a crystal clear manner until otherwise it is getting interpreted by some judicial organization. So judiciary needs to come and tell some answer. Until otherwise they reveal, we cannot tell what will be the final choice. That is why they have mentioned in July 2013, the Supreme Court, they dealt the tussle between the Lieutenant Governor and the elected government in Delhi, whether they can solve this or not. When judiciary involves, they will tell crystal clear what is correct, what is incorrect. And whatever they declare in that area, only based on that, the so-called government has to function. We all know pretty well, they are the one who are considered to be the so-called guardians. They are the one who are considered to be the interpreters of the constitution. So what they say will remain final. So keeping those inputs in mind, let's begin with the answer. Introduction for this area, how to give. Supreme Court and Delhi is having a controversy. whether the governor, the Delhi Lieutenant Governor, whether he can function independently or he needs to function based on the advice given by Council of Ministers. That is the big area. Lieutenant Governor will have an opinion that only when I sign, your bill is becoming an act. Only my signature will convey that your bill has become an act. Why I have to obey you? I will work in the way what I like. I am not your employee. I am appointed by the Delhi, that is the so-called union government. Now, whose decision we have to take? See, Delhi and this state capitals are sometimes very tough to work because we do not know from where authority will flow. Likewise, in this area, they are declaring that the Supreme Court and Delhi, the so-called government, in case of the Delhi government, the Lieutenant Governor, as well as the issue on the Council of Ministers went to Supreme Court of India, and now there is a talk going on in this topic. For that, we got a message that Delhi is having a special status as per Article 239 AA. 239 AA is giving a special status to Delhi. You all should know there is a committee report called as Balakrishna Committee Report. Balakrishna Committee Report, way back in 1987, that time they declared Delhi is not a statehood. Am I right? Delhi is not a state. So what a state is having the element of eligibility, Delhi cannot enjoy that. So Delhi will never come under the element of statehood status. So that we have to stop. After having this input, we can proceed for the area which is considered to be the domain on the so-called issue relating to constitutional status of what a Delhi can do. Whether Delhi is all empowered to do things what they like, or Delhi has to function only based on the advice given by Council of Ministers with the Chief Minister. Now the matter is going to Honorable Supreme Court of India, and now the issue begins. Who is having the power? Whether Council of Ministers with the CM are more powerful, or Lieutenant Governor can decide everything whatever he wants. This is the issue. This looks a very simple topic. Am I right? If you ask a layman, who should decide these things? Whether people representative or the agent of the union? All will say people's representative. That is what Supreme Court also said. See, sometimes when you don't know the answer also, you can please go by this area to convey the message. When you do not have the awareness of the answer, think slightly rationally. You will get the input. This has to be applied only in rarest of rare cases, not regularly. So here the message has become very simple and clear that 239 AA in case of the Delhi, which is getting a special constitutional status, is based on this particular phenomena. Now what is the body? Delhi High Court declared that Lieutenant Governor has all the powers towards Delhi government, therefore conflict begins. So in Delhi we have two places. One is Delhi High Court, Saket, what we call. Then we have the Supreme Court of India in Delhi behind the India Gate. So Delhi High Court, when they say something, it is relating to all matters of administration under New Delhi. On the other hand, all appeal from the Delhi will go to Delhi Supreme Court. Other states will go to Supreme Court. Likewise, Delhi High Court also, all appeal will go to Supreme Court of India. Now the High Court is making a statement. In that they are declaring Delhi High Court is having all the Lieutenant Governor is having all the power and they can decide anything and everything whatever they want. Now Delhi government is feeling annoyed. How come they can make this judgment? How come a people's representative are less powerful than the person who is considered to be an agent? How agent is all powerful and how the people representative are less powerful? That is the debate they are having. An unending debate as such. So they are not having a clear answer in this perspective. Therefore, to bring a solution, they went to Honorable Supreme Court of India and banged the door of the Supreme Court. Now, Supreme Court is duty bound to give the answer in this perspective. The Supreme Court of India now is having a mandate to tell what to do. Supreme Court declared that as per Balakrishnan Committee report, Delhi is not a state. A finite answer. They have made the statement very clear. Delhi is not a state, and they made a statement that Lieutenant Governor is bound by the aid and advice given by Council of Ministers headed by Chief Minister. Lieutenant Governor can reserve certain thing for the President, subjected to condition that the Lieutenant Governor feels this is very vital in terms of the issue. Otherwise speaking, other things and all he can't keep on reserving for the President. He needs to work based on the principle of asking the so-called respective state. Until otherwise the state is giving a consensus, he cannot move forward. That input became very clear as such. Now they are very happy in that area. Supreme Court resolved the issue, thereby ending the long-standing tussle. What was the crisis? What was the issue? It got resolved to a largest extent. They were able to tell very comfortably that yes, this issue pertaining to the fact that whether the Lieutenant Governor or the Delhi government headed by a Chief Minister who is powerful. I told you in previous classes also, power is a relative concept. Nobody can claim it as an absolute power. It is always subjected to some or the other issues. In that, we got a big clarity that the issue of power in terms of governor, the lieutenant governor for union territories, in state we call them as a governor, in some UTs we call them as an administrator. The lieutenant governor is having a big amount of mandate wherein which he is supposed to work only based on the advice given by the so-called Council of Ministers with CM. Otherwise, he cannot proceed forward. Ultimately, what happened? Elected government became supreme. The people's representative, the people's choice is now becoming the final choice. All the people's representative are being subjected to the highest authority. But we have a condition here. The condition is that the question relating to the issue on this particular judgment conveys the message that constitutional morality is getting reconfirmed. Yes or no? Constitutional morality in this area is what? That who is the highest authority? Constitution itself starts with the preamble. In preamble document, there is a message that we the people of India. When we the people of India comes into picture, the power is starting from the people. When people are powerful, then we have to convey the message that in this topic, the issue of constitutional morality is getting reconfirmed. And therefore, this verdict is considered to be a precedent, excellent precedent set by Supreme Court of India. They only reconfirmed that this judgment is again subjected to large amount of happiness. Why? We confirmed. Always speaking, the sovereign power will remain. The people's representative will be powerful. Therefore, we have to go by the terms given by them. So whether the long-standing issue has been solved or not means it got solved. It got a great amount of message in conformity that no more they will accept the element of Lieutenant Governor controlling the aspect of the Delhi government. So what is the conclusion? The major crisis got solved. We had a major apprehension. Who is powerful, who is less powerful, but now we came to a grand conclusion that the issue on this crisis got resolved. There is no doubt in that. But the question of statehood still remains unresolved. We are not able to come to a conclusion. Why the question of statehood is not being concluded is a big debate for which no answer is there. When they are not able to conclude these things, when the issue is not going as per the dictations, then crisis will again erupt in some perspective. A state will enjoy certain things. Delhi government will try to enjoy the same thing. When that is not being permitted, the problem will start again. Though the current crisis got resolved, the current problem, whatever they had, it got resolved. There is no doubt in that. But other issues, whether the state of Andhra Pradesh, Karnataka or Madhya Pradesh, whatever they are doing, whether we can do or not. We are also having CM. We are also having MLAs. Are we equivalent to a state or not? That is the question for which even till today we do not find an answer. That conveys a louder message that until otherwise this issue is getting resolved, the crisis may also arise in the days to come. So in this topic, you write the answer with this conclusion so that your answer looks like a matured answer. and this answer is enough to write the question on topic of lieutenant governor and CM and council of ministers crisis, right? So with this we can as such stop for the day, and we will see the other subjects as other questions as such in the upcoming session on coming Wednesday evening 9 p.m.